All right, thank you. Good morning, Mark Scheibmeyer, the city's hearing examiner. I was convening a hearing to consider the appeal submitted by Roberta Brown, appeal number APP 23-00003. The matter is entitled Brown versus Issaquah and Links Consulting, having to do with the wireless communication facility proposed on school district property. In advance of today's hearing, I have received materials from both parties and have reviewed all materials that have been provided to me. The record should reflect that the city appears today through Anne Marie Soto, city attorney or assistant city attorney, I'm not certain which. Links appears through Richard Bush, its counsel, and the appellant Roberta Brown appears pro se, but is also an attorney. And again, I have reviewed all materials in advance. I have received lists of exhibits from both parties. We'll admit both lists. That's city's exhibits 1 through 4 and the appellant's exhibits 5 through 9. All are part of this record. By prior order, prior announcement, I advised the parties that I would follow the request of the city and the applicant that they present first, followed then by the an opportunity for the appellant to respond. So with all that in mind, are there any preliminary matters that any of the council wish to bring to my attention? Hearing none, let's get underway. So Ms. Soto, how do you see us progressing?
Mr. Scheibmeyer, I
Yes.
apologize if I said your
That's
name
fine.
incorrectly.
No, you didn't.
The city actually does want to place an objection to introduction of the appellant's exhibits because they go beyond the scope of what was allowed to be heard as part of this remand hearing. And so I want to get that on the record.
I somewhat anticipated that argument. I'm going to deny the city's motion simply because, again, all matters will be decided by me rather than looking at them on a case-by-case basis at this point. I'll sift through them finally when I come to making my decision. I feel I'm capable of separating wheat from chaff in that process. So I do note that they tend to wander from what appears to be the subject for this appeal. But I'll simply, while recognizing that, rather than denying their admission, I'll simply consider that at the time I'm making my decision. But I do understand the motion. With that, anything else preliminarily?
One other item is the city and the applicant discussed and thought it would be better for the applicant to go first to kind of explain what they have submitted, and then we would follow up with the city's witness going over what the city reviewed as part of their application resubmittal. Okay,
that's consistent with my earlier announcement. My goal is to simply have it laid out to me in as straightforwardly process as possible so that we can then use that foundation to work on the appeal issues. So your suggestion makes sense in that regard. I don't have a problem with it. With that in mind, Mr. Bush, how would you like to proceed?
Thank you. We do just have one witness to explain the process after the initial hearing examiner's decision, Jennifer Taylor, who is on the screen right now. And we anticipate just reviewing the exhibits, some of the portions of the exhibits that we have offered into evidence.
Okay.
And if I'm able to share my screen, I'll bring those up as we talk about them. If I'm not able to share my screen, I'll just ask everyone to imagine the exhibits. So we will go ahead. So our testimony today by Jennifer will basically focus on the only issue that the hearing examiner remanded for reconsideration, and that's the access route from the public right-of-way to the licensed premises. And so she will indicate that that has been resolved through the execution of the long-term license agreement. The route does connect both to the premises pre-construction by the school district and post-construction. And then we'll turn it over to the city to talk about its review process. So with your permission, we'll swear Jennifer Taylor in.
Just before I do that, let's make certain we're all of a like mind and how cross-examination will proceed. So all witness, this being an appeal hearing, a quasi-judicial hearing, all witnesses are subject to appeal. In this case, we have a three-legged stool. We have three parties to the matter, and therefore we have the opportunity for cross-examination by two other parties. So what I would anticipate after Mr. Bush's witness has testified, that Ms. Brown, I'll allow you the opportunity for cross-examination, and Ms. Soto, if you have anything, you can do so as well following Ms. Brown, and then we'll circle around again through that process. So just so when we complete the direct testimony, the parties can anticipate that order. And so with all witnesses today, they will be Ms. Brown, you raised your hand.
Yes, I just had a question on that. So cross-examination, you're saying would take place before I have an opportunity to present my testimony?
Of course, you're given the opportunity to cross-examine their witnesses before you're asked to testify. So that's a privilege accorded you. It's not a burden, it's a privilege. And yes, you will be allowed the opportunity to cross-examine Ms. Taylor or any of the city's witnesses in advance of you providing your own testimony.
Or after my testimony, is that correct?
I'm sorry?
Or perhaps after my testimony.
I don't know why. I can't think of a reason why it would occur then. You can ask to consider it, but normally at that point I would have released the witnesses once they've testified and have had that opportunity. I'm disinclined to generally require witnesses to remain in attendance at that point unless their counsel wishes them or they wish to, but short of that, most likely those witnesses are going to be released. And so if you want to cross-examine them, your best opportunity would be as part of their immediately following their direct testimony. So let's get underway with Ms. Taylor. All witnesses who testified today will do so under oath. So Ms. Taylor, I should, for the record, note that this hearing is taking place remotely with parties, some in attendance at city facilities, the rest attending remotely, including me. The city is utilizing the Teams format for conducting this remote hearing and is serving as the host. Ms. Taylor appears to be appearing remotely. Ms. Taylor, let's have you sworn. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Bush, go ahead.
Great, thank you. If I may, just with a preparatory comment, hearing examiner Scheibmeier, I believe you said during your introductory comments that the appellant also was an attorney. I will certainly let her speak for herself, but I don't believe she is. That may help clarify some of the procedural questions.
Thank you. I assumed that from the briefing materials, or maybe something else I'd read. I apologize. Well, I hope that's not casting aspersions on your character by claiming you to be an attorney. And thank you, Mr. Bush, for clarifying that point. And I will. That is somewhat valuable information to know, in that non-attorneys, I grant a little bit more latitude, recognizing that some technical aspects of the presentation may not be as well understood, and that I will allow some degree of flexibility to accommodate what may not be commonly understood notions, whether that applies to hearsay or relevance or various other legal theories that may come into play. I will grant some leeway. I won't grant total leeway, but I will grant some, recognizing that there may not have been training in some of those fields. So thank you, Mr. Bush, for pointing that out, and let's get us underway.
You're welcome. Thank you. Okay, Ms. Taylor, if you don't mind, your name, employer, and title.
My name is Jennifer Taylor. I work for Lynx Consulting, and my title is Real Estate Manager.
Okay. And could you briefly describe your responsibilities as a real estate manager generally?
I do both project management and handle aspects of leasing processes for telecommunication projects, whether that's licenses, leases, easements. I also handle some permitting aspects, building permits, land use permits, and as part of the project management sort of oversight of the design of new development projects.
Okay, very good. And you've been involved in this, the subject matter of this appeal, the Providence Point, what we're calling the Providence Point Relocation Project?
Yep, I've been involved since 2023. The project did start before me, but I've been involved since 2023 and was part of the previous appeal hearing.
Very good. And you've been handling all of the same responsibilities you just described as a part of your job, the permitting and leasing. Okay.
Yes.
The prior hearing examiner's order did require additional work, if you will, on the access route. Can you describe what you did after the hearing examiner's order came out with respect to the access route and the license agreement and exhibits?
So the license agreement for the final permanent site was still in negotiation at the last hearing. And after that hearing, we just made sure that the way we're describing the access is extremely clear in the agreement and that it fully covers the entire path, which access onto the property will be using, which path through the property, all the way extending to the new compound area.
Okay. And if I may, am I able, do I have permission to share the screen with everyone? I see it's grayed out.
Let me check my settings real quick.
Yeah, thank you. And hearing examiner Scheibmeyer, I do plan to show exhibit 3, which is the the applicant's exhibit 3, which is the site plan, and then a portion of exhibit 4. So if you do have it, if we're not successful, that's not a big deal. I just wanted to be able to share it with everybody.
I do, and both in paper and I've got a separate screen to follow exhibits as well. So yes, in multiple formats, I have it. And to make your job a little bit easier, Mr. Bush, you can refer to me either as Mr. Hearing Examiner or Mr. Scheibmeyer, but the longer term that isn't necessary. So.
Okay, thank you. You want the hearing to be shorter than.
That's right.
Okay.
That's right.
Okay, I do see the share button is activated. Thank you. Now, if I can pick the correct screen, we'll be in good shape. Okay. And hearing examiner, how would you like to, so hearing examiner, how would you like to handle the introduction, the offering and introduction of exhibits and evidence, one at a time?
In my introductory comments, what I intended, perhaps what I did not do clearly, was to pre-admit all of them. And so all 4 of the combined exhibits proposed by the city and the applicant have been acknowledged as exhibits 1 through 4. And again, the appellants have been acknowledged as exhibits 5 through 9.
So I turned off my hearing when I heard that you're denying the motion. So my apologies. Okay, I'm sharing hopefully the exhibit 3 proposed site plan. I'm making it as large as possible for legibility purposes. But Ms. Taylor, could you describe what we see on the site plan, both the access, including the access route, the utility easements, and the premises?
Yes, so starting sort of at the, I'll say upper right, the call out's a little hard to see, but it calls out the proposed carrier ingress and egress from 228th Avenue onto the Providence Heights Loop Road. So that's the north entrance. Our path will start there, continue up, and then turn down roughly halfway through the property to the south, connecting to where the 60 by 60 lease area is at the sort of lower middle of the page. So that's calling out our non-exclusive 15-foot access right-of-way per the license agreement. And then it continues down. It does take a turn that would be to the left or the southeast to access into the new compound area. The road itself does continue and links back up with 228th Avenue Southeast on the south end of the parcel. Our utility easement does follow that path, but our access onto the property was from the north.
Okay, just to clarify, does the access easement continue south along the grade area where we see the numbers 160 feet, or does the access not continue past the licensed premises?
Yeah, the access easement will stop at where it turns into the compound. And
Very good.
then that for the ingress and egress easement path. The utility easement path is separate, and that's the one that follows the south property line.
And those are just for clarification, the utility easement are the two dashed lines above the solid line at the southern portion of the property?
Yes.
Okay. And then in order to install the utilities into the utility easement, I assume there will be temporary access by machinery to install the utility facilities.
Yes.
Okay, but the southern portion we're looking at will not be used for access.
Right. Yeah. So the agreement is specific, and that the ingress and egress comes from the north entrance.
Very good. Okay, and what I'll do now is scroll down to a portion of what is Exhibit 4. Exhibit 4 is the long-term license agreement, and I've selected 2 pages from Exhibit B2, the long-term license agreement, at pages 22 and 23 in the license agreement itself. And again, it's hard to read, but if you can describe what this exhibit shows in the license agreement.
So this is showing that 15-foot non-exclusive right-of-way coming from the north end of the property entrance from 228th, passing through the middle of the property, shown as a dashed line or double dash line, down to the 60 by 60 lease area on the southern end.
And does that route connect to the licensed premises?
Yes, it does.
Okay. You know, I forgot to ask on the prior screen, there is a grayed out area around the access easement. Can you describe what that grayed out area represents?
Yeah, that was shown on the underlying survey that was used as the CAD file for the site plan as what is asphalt on the property.
So that's current asphalt today. It has nothing to do with our access route.
Right.
Other than the fact that it overlaps.
Yes.
Okay, thank you. And then going to what we just looked at, is this the access route pre-construction by the school district or post-construction by the school district?
This is pre-completion of the school district's construction project.
Okay, and then going to page 23, which is the second additional page of Exhibit B to the license agreement, which is Exhibit 4 on the remand hearing. There we go. Can you describe what we see here?
Yes. So this is the page showing the expected access route after the school's construction project is complete. So this still enters in from the north end of the property, follows more along the north end of the property before turning south and continuing down to the license area.
Very good. And again, it connects to the licensed premises.
Yes.
Okay, thank you. I'll stop sharing my screen, I think. There we go. Thank you. And then the hearing examiner's decision requires the access rights to continue as long as the tower is used on the property. When the agreement terminates, do the carriers have any obligation about removing the tower at the end of the agreement?
The license agreement does state that when the agreement terminates, that the carriers will have to restore the property within 30 days to a previous condition as near as possible.
And that includes removing the tower and the equipment improvements and things like that.
Yes.
Okay. And then the access rights under the license agreement continue until the tower is removed.
Yes.
Okay. Thank you. I have no further questions for Ms. Taylor at this time.
Let me vary my order just a little bit to be a bit, I think, more efficient. We'll go with Ms. Soto to see if she has anything she wants to add, which then allows Ms. Brown a more comprehensive opportunity for cross-examination. So Ms. Soto, any questions you have of the witness?
No questions for this witness. Thank you.
Okay. And so Ms. Brown, any cross-examination?
So I have a few questions. Can you hear me okay?
Yes, I can.
I appreciate the presentation. Thank you very much, Ms. Taylor. You mentioned that when you trace the route, the pre-construction route, if you will, that an easement will be, you use the future, provided from in the latter part. I understand, I've seen all the surveys, and there is an access easement in the upper part, but not going down to the site itself. So is that easement in place now, or is that a plan to?
No, the easement is in place. The easement rights are granted as part of the license agreement itself. So it's all encompassed in the license agreement of Exhibit 4.
So the easement rights are granted, you say, but is there an easement? There's a difference, as you know. These are two entirely separate instruments.
There is no distinction between those to me. I'm not sure what you're asking, Ms. Brown. Easement and easement right are coextensive terms. Maybe you can refine your question because I don't understand it.
Sure, I appreciate that, as you know, yes. My understanding is that the license agreement, as I will explain in my own testimony, is separate from an official recorded easement. So I'm asking if that official recorded easement is in place.
Oh, I'm going to have to, I'm struggling a little bit, Ms. Brown, and we're utilizing certain terms of art and we're not utilizing them well. A license is different from an easement.
Yes.
Both grant access, but they do so in somewhat different ways. I cannot give advice, but the early order speaks of access. It doesn't necessarily speak to the form of the document that grants it. A grant of access can be by a license. It can be by easement. And so that's where I'm getting caught up in your question, and I'm not quite certain what you're asking. Therefore, the question itself becomes uncertain to me. And if it's uncertain to me, I don't know how the witness can necessarily answer it accurately. So I'm trying to clarify that so that we have something that the witness can clearly respond to. Let's go off the question a moment and sort of better understand where you wish to go with that question, and that may help in understanding or in framing it properly.
I think I'll wait for my own testimony.
Okay, all right.
Thank you very much for the clarification. I appreciate that. I'm also, my other question is this pre-construction access route. My understanding is that this whole project is occasioned by the proposed or by the possible demolition of the water tower on which there's a WCF now. So if the water tower does not be demolished, and we don't know at this point, what gives you gives the applicant the right to go in and do that? Could you kind of explain that in a legal perspective?
If this is a question for me, I'm not entirely sure I follow, but the applicant has applied to construct a new communication facility and to relocate all parties onto it in preparation for the removal of the water tank. But it also is providing additional height so that and a bit more of, I would say, like structural integrity, capacity as well, by being a new structure instead of a considerably older water tank. I can't speak to exactly much about the water tank removal because I'm not part of the school district's project with that regard, other than we've been given notice that it is being intended to be removed.
Thank you. I think you're right. I agree with you. More structural integrity. I just wanted to follow up on that. That's very interesting. I didn't see it in any of the materials. Could you just maybe just highlight that a little? And I think this will be the.
Yeah, I'll object to the question because it's beyond the scope of what the appeal hearing is.
Ms. Brown, I'd like being transparent as I proceed through hearing so that the parties know what I'm thinking about, and therefore it helps frame what they want to ask about. I'm not interested in the old tower or its location. That's not before me. I haven't been given authority to think about it, and therefore I don't find questions about it helpful to my decision making.
Absolutely right. Thank you. I appreciate it. I think that's the end of my questions for now.
Okay, I have several questions of the witness that the parties may then cross-examine further after I've posed my questions. Ms. Taylor, I want to turn to Exhibit 4, the license agreement, and talk about a few things. So, so it's effective April 26th of this year, correct?
Yes.
Okay, and per its terms, it's a license that is in effect for 10 years plus 2 automatic 5-year renewals. Effectively, it's a 20-year agreement.
Yes.
Okay, so at the end of 20 years, there is no right for this facility to continue to be used.
No, at the end of 20 years, they would either need to renew or complete a new agreement, or it would otherwise terminate.
Well, currently there is no other agreement, so unless something else happens later, this ends at 20 years.
Yes.
Correct? Okay.
Yeah.
And the right to continue a tower beyond 20 years does not exist for this agreement or any other agreement.
No.
Okay. So absent a new agreement, this is a 20-year experience, which then terminates and the tower must be removed unless a new agreement is entered into and appropriately approved.
Correct.
Okay. I want to turn to paragraph 6, which is entitled Access and Coordination. I get a little lost in its provisions and want you to help work me through that. So about the third sentence, it begins, if licensors' use of the property will temporarily, licensor being the district, use of the property will temporarily prevent licensee, where to go? And its sublicensees from accessing the site using the designated ingress and egress route. Licensor shall notify licensee in writing in advance of such interference and will make best efforts to designate an alternate temporary ingress and egress route. It goes on in the next sentence to note, however, that it doesn't guarantee access, but that it will utilize its best efforts to achieve alternate access, but doesn't assure alternate access during that temporary basis. Would you agree with my reading of the document?
I believe that it says, it's intended to say, let me finish reading the rest of that paragraph, but that the licensor will make sure that we have 7 days a week, 24-hour access. If there's going to be interference, which part of this section was intended during the school district's construction period, there may be times that the route we are taking will be blocked as they're actively constructing it. So that would allow them to provide us a separate access route. But it does have to be in that second sentence about it may not be allowed to use the alternate ingress or egress routes unless agreed to in writing in advance. So that's a way
So-
that we're saying it
okay.
has to be documented, which route we are allowed to take during that times of potential interference.
Let me paraphrase the paragraph and you tell me if I'm going off the rails with its provisions and if so, where. But it acknowledges that construction of the schools may, not surprisingly, create an access issue. But if that should happen, that the school district will exercise its best efforts to promptly find a new access, but at no time is the licensee automatically entitled to use the south access. And it's only if the school district approves an alternate access does that access then become available to the tower.
Yes, I think that's the what it's intending to say.
Okay. Where my concern arises in that reading is that there could be periods, temporary periods, where there is no approved alternate access. And I'm wondering whether that is in compliance with the terms of the earlier variance and the earlier order. How would you respond?
I don't think that it's saying that there may be times of no alternate access. It's saying that we will work together to ensure that there is an alternate access as it's required per the lease to have access at all times.
Okay.
So to me, it's saying by saying it's unless agreed to in writing, it means that we have to document it. And you can't just use any alternate route. But the previous language does say that they will provide access of some sort onto the property at all times.
And keeping in mind that I can't tell the school district what to do. It's not a party to this matter. Therefore, I can tell your company what to do, but I can't tell the school district what to do. I am concerned as to my ability to assure that the school district does in fact promptly provide you with alternate access in the event of a construction delay or construction obstruction. And if you have anything else you'd like to respond to about that concern, feel free.
Yeah, I don't think so. Reading this while I'm trying to talk at the same time, I would refer up to the, it'll be the 5th line in section 6. And it states where it describes access as being depicted on Exhibit B, said exhibit to be modified by the district in its sole discretion, so long as access to the site is maintained. So that is the sentence that's saying at all times the district will make sure that the carriers have access to the site.
Okay, that's an excellent response. That's a very helpful one. I appreciate that. Thank you. In light of my questions, the parties are entitled to cross-examine based upon the questions I posed. Mr. Bush, do you have any follow-up that you would like to raise?
Yeah, I think it would be helpful if we put the timeline on the table for discussion, because there's different types of access required depending on our timeline versus the school district construction timeline. So I will expand the question about access and put it kind of more on a timeline.
Sure.
So Ms. Taylor, when the wireless communications facility is initially being constructed, what type of equipment and vehicles will be brought onto the site?
So there'll be trucks and a crane, other types of, I'm assuming, clearing and grading type equipment, of which I'm not specifically familiar with all the names of those things. There certainly will be probably some larger trucks delivering equipment and delivering materials as well.
Okay. Cement trucks, bulldozers, excavators, large construction type.
I would describe it that way.
Vehicle.
I don't know specifics of the construction.
Sure.
Mr. Bush, let me stop for a second. In the same way I was trying to express my transparency to Ms. Brown, I should also do the same for you in the city, in that I find myself in this unusual situation in this hearing in that the reasons for the access aren't necessarily relevant to me because I'm not being asked to decide whether access is a good idea or why it's needed, but simply that it's to be imposed. And again, because it comes to me in a prepackaged form where I am limited in what I'm to be considering. And as a result, I'm not sure uses. I don't have a problem with you presenting testimony in that regard, but I'm not certain how relevant some of that becomes because of my very restricted role in this instance. So just giving fair notice that I'm trying to get a sense or trying to decide internally how important some of that action is to me because of what I've been told to do in this hearing. So just giving fair notice of that concern.
I appreciate that. You are inquiring about the potential lack of alternate access during an active construction
Yes.
period.
Yes.
And I was seeking to provide information about, and it doesn't require practical considerations about what's involved. After the site is constructed, the access that the carriers need to the site is almost walk on with handheld equipment.
Right. I've done 50 tower hearings in many jurisdictions. I understand
with
wireless
apologies, yes.
I understand wireless communication facilities, and I'm not speaking in a talking down way. But just to make clear that this is not the first rodeo on wireless facilities, and so I understand there's an initial entrance, and then they basically go to sleep. I recognize that, but I think some further explanation is fine. Again, I'm repeating myself. I just find myself in a most unusual situation in this hearing because some blinders have been put on as to what I am to be thinking about. And so my normal considerations have been altered by the directives of the prior order. And I'm trying to keep from both sides, I'm trying to keep within the confines of those earlier directives and not wander away from them.
No, we appreciate that. And we're in the same situation, I assure you. Okay. With your comments, I don't have any additional questions for Ms. Taylor.
Okay, Ms. Soto, anything?
Nothing from the city, thank you.
Okay, and Ms. Brown, any further cross-examination based upon my questions?
Not at the moment.
Okay. By the moment, I'm going to excuse Ms. Taylor unless Mr. Bush wishes her to remain in attendance. Is there any reason you wish her to remain?
No, she can be excused.
Okay. Ms. Taylor, you are excused from the hearing if you don't wish to remain in place.
Thank you.
And does that conclude the applicant's presentation?
Yes.
Okay. Turning then to the city, Ms. Soto, what would you like to present?
We have Director Dollywall here to present today.
Okay.
All right.
Give me a second.
Okay.
Just give me a moment. So that is Minnie Dollywall.
That's correct.
And Ms. Dollywall, let's have you sworn. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead, Ms. Soto.
All right. Minnie, could you please say your name and your title and how long you've been with the city?
Sure. Minnie Dollywall, spelled M-I-N-N-I-E. Last name is spelled D-H-A-L-I-W-A-L. My title is Community Planning and Development Director. I have been with the city since 2021.
And can you just describe a little bit what you do as the Director of Community Planning and Development?
Yeah, as the director, I oversee our staff that reviews all the land use applications and construction permits, and also inspection staff that then takes these projects to the finish line.
Okay. And Do you have familiarity with the Issaquah Municipal Code and its permit review procedures?
Yes, I am very familiar with Issaquah Municipal Code and permit reviews.
And are you familiar with the underlying ASDP, so Administrative Site Development Permit 2022-0007 that is on appeal here under appeal number APP 23-00003?
Yes, I'm familiar with it. I did attend the previous hearing as well.
Okay, and just for everyone here, you were not the original planner to review this project, is that correct?
That is correct. Staff that actually was reviewing the project is no longer with the city, so I am here on behalf of, but I have been involved in the process all along.
Okay, and so what was your specific involvement with the reissuance of this ASDP 22-00007?
So ensuring that, it's complying with the condition from the hearing examiner, the remand order was being met. So we wanted to confirm that that was what was going on with when we reissued the decision and helping our staff who was reviewing the project at the time.
Okay. And so you've still reviewed the files for this reissuance, even though you were not originally on this project, correct?
Yes, I'm familiar with them. Yes.
Okay. All right. So turning now to the ASDP at issue, just a couple of quick, just general questions. Are there any requirements in the Issaquah Municipal Code related to access for a level 2 ASDP for a wireless cellular facility?
No.
Okay. And are there any specific access requirements in the Issaquah Municipal Code for a wireless cellular facility that needs a height variance?
No.
But here we do have this access requirement. Do you know where that access requirement came from?
I think it was put as prior to the issuance of the site development permit, there was a condition added to the ASDP that the applicant shall provide this access to the lease area stemming from the original decision. And then I believe so it was more like for your information, like a checklist of things that needed to be confirmed, not so much as tied to not meeting the approval criteria for ASDP. It was more as an FYI, but it is listed as a condition of approval, which then got carried forward in the hearing examiner's decision on the variance.
Ms. Soto,
Yeah.
once again, let me, I promise the parties I normally don't interject as often as I am in this case, but it is such an unusual situation with unusual parameters. And I'm trying to keep everybody understanding of how I view it. And I'm a bit concerned about that question because I normally would believe that the documents speak for themselves, that Mr. Seidel's established this. If his documents say why, well, then his explanation certainly has great relevance. Or if other documents say why, then those documents become incorporated and help explain his decision. But anybody's opinion as to what Mr. Seidel's intended is worrisome to me. I'm not quite certain as to how I should take that information. I simply have his decision, both in his variance and his earlier order, and whatever language that he added to those. But as to why he did that, I'm not sure if any witness is entitled to express their opinion as to that. They can certainly present documentary evidence that helps explain it, but I'm not sure how opinions move this ball down the field. I should note also that in Mr. Seidel's variance, he points out that he's looking at the map and he sees the road on the map. And he simply notes that while there's a road to the compound, there's no access agreement for the use of that road. And he's bringing that to everyone's attention and saying, I see where this plan provides for a road, but I don't see assurance that it can be used. I want to see that assurance that it can be used. I think that's a fair paraphrasing of his earlier orders. And so, sorry for that long-winded interjection into your question, but I just want to, I'm trying to keep all the parties within a relatively narrow confine. So with that in mind, go ahead.
Yes, and just to clarify, I'm really just looking for the how the city got to the requirement that we look at access and what specifically we were required to look at as part of the hearing examiner's prior orders, not necessarily looking for an interpretation about those orders, but just looking for explanation as to what it is that we were looking for. So Ms. Dollywall, as you're answering your questions, if you can respond just based on what is in the orders and what you were looking for to comply with those orders is really what I'm trying to get at here.
I can answer that. In terms of the variance decision, the specific requirements in your Exhibit 2, page 9, state prior to issuance of ASDP, the applicant provides their access easement to use Providence Loop as access to the lease area or revise the access location to a different location. That's what's in the variance condition.
Okay, and so then, as we all know, after the hearing on the appeal for the ASDP, we then got this requirement for the applicant to submit information that gave them access in accordance with that variance decision. Is that correct?
That is correct. So that's on page 9 and 10 for Exhibit 2, where the hearing examiner decision gets into those details.
Okay. So moving on then, what did the applicant submit to the city to show that it had access?
We received a site plan, that's the Exhibit 3, and the license agreement, which is the Exhibit 4. And as the applicant testified and explained, the pre-construction timeframe and then post-construction timeframe, those are all part of that license agreement. Those are graphically shown on those two pieces that are embedded in the license agreement.
And from the city's perspective, did that license agreement provide the applicant with sufficient access to the site in compliance with the hearing examiner's prior orders?
Yes.
And also in the hearing examiner's prior order, I believe, and I want to read directly from the order. So in his decision, and this is the city's remand exhibit number 2, page 11, he specifically says that on remand, the department may modify ASDP 22-00007 if and only if the applicant submits revised site plans depicting lawful access to the lease area for the lifetime of the cell tower is required by variance 22-00003. Is that your recollection of the hearing examiner's order?
Yes.
Okay. And so looking at the license agreement, as we heard the applicant testify earlier, there's an initial 10-year term and then 2 automatic 5-year extensions. What is the city's position on what would happen if that license agreement were to expire?
The facility would go away.
And
or the license agreement is extended, unless it is extended. Yeah.
Okay. So if there is no right to use the property for the wireless cellular facility, then there would also be no need for access. Is that correct?
That is correct.
Okay. And is there any reason to believe that this access, other than the fact that there is a pre-completion the pre-construction completion access and post-construction completion access. Is there any reason to believe that this is otherwise a temporary access?
No.
So after the city staff reviewed the materials from the applicant, what did the city do after that?
The city reissued the ASDP decision that was sent out, and part of that was to part of the hearing examiners was to reopen this, and that's why we're here tonight, this morning.
Okay. All right, I have nothing further.
Thank you, Ms. Soto. Mr. Bush, any questions of Ms. Dollywell?
Thank you. No questions.
Thank you. Ms. Brown, any questions?
I don't believe so at the moment.
When you look down at your paperwork, your microphone doesn't pick you up very well.
Sorry, I apologize.
That's all right.
No, I think I'm good. Thank you.
Okay, thank you. So that concludes Ms. Dollywell's testimony. And again, as a city staff, I think your presence will be determined by whether Ms. Soto wishes you to remain in attendance. Ms. Soto, any other witnesses that you would like to present?
No other witnesses for the city.
Okay, so we've received the presentation by both the applicant and the city, which brings us then to the appellant. And so, Ms. Brown, this becomes your opportunity to present either through other witnesses or your own testimony. But to the extent that you are testifying, you are subject to cross-examination like any other witness. And one of the challenging things that is always present with representing yourself and testifying is this distinction between testimony and giving factual information and legal argument, which really is to wait until the case is completed, all testimony has been received, and everybody is given the same opportunity to make legal argument. There is some latitude in that. It's really difficult to create a clear line between the two, but let me simply try to advise you that when and if you decide to testify, you are testifying as simply as a witness. There will be a moment a little bit later in which you are given the opportunity to make legal argument. And so I would encourage you to hold off on legal argument until that final series of arguments by all counsel. I don't know how well that's interpreted, and I'll leave to you to try to decipher that and do as best you can. But with that in mind, who would you like to have testify first?
Myself.
Yourself. Are you anticipating any other witnesses? Okay, so you are the witness. All right. So let's have you sworn. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Go ahead.
So, yes, I just want to thank you for the opportunity to speak and to present myself. I have some short comments to make. I'll make this as efficient and clear as possible. And I have just 2 points to make. First, I appreciate all that has been said, but still, there is no access easement to the proposed Verizon C project site. And secondly, there is a major amendment to the Issaquah School District land use permit on the property that is pending. It's material facts. The access easement, I'd like to clarify this, and I'd appreciate your experience too with this. So I'll go back a little bit. As you recall, the first application that for the height variance permit was submitted on November 4th, 2022. The hearing examiner decision on the variance was dated October 26, 2023. Administrative Site Development Permit, ASTP 0007 for the Verizon C Providence Heights project was subsequently issued. And I submitted the appeal to it on November 14th of 2023. And as we've discussed in his summary of decision on the appeal, resulting in a remand of the application to the city, hearing examiner Alex Siddles wrote, as we've said, prior to issuance of ASEP 220007, the applicant provides their access easement to use Providence Loop as access to the leased area or revise the access location to a different location. This is an exhibit 2. He further stated they had supplied site plans showing the 1997 easement itself. However, the water tower and the lease area are nearby to one another, but they are separate locations and require separate access. He is addressing the easement, not the license here. Finally, he wrote, although consistency with the variance is not, formally speaking, a criterion of approval set forth in the code, the hearing examiner will not allow a previously ordered condition of approval to be overlooked, as you mentioned. Now, according to the hearing examiner, what was missing from the current application was a legal easement equivalent to the 1997 easement agreement for the entirely separate water tower site. As we know, the 1997 easement agreement for the water tower site presented by city staff at the last hearing is a formal, legally binding easement document recorded in the county recorder's office, providing in this case it was GGE MobileNet Incorporated and successors permanent non-possessory right for vehicular and pedestrian access to a portion of the grantor's tract and its successors to maintain and operate a telecommunications facility. Now, an equivalent easement providing permanent access to the proposed new site and delineating the exact location using survey document of that access is still missing. Looking at what we have now, the license agreement signed April 26, 2025 between the Issaquah School District and Seattle SMSA Limited Partnership does not satisfy the requirement in the decision, which was to provide an easement for lawful access to the lease area for the lifetime of the cell tower. The license agreement we have before us is simply a non-binding, temporary contractual right, basically a financial agreement. It does not convey interest in the property itself, and it can be terminated by the landowner at any time should the need arise. In short, there is no easement as required by the order of the remand. I have just one other little point to make, and this regards the major amendment. Looking now at the matter of easement as it relates to the parent property, on August 7th, just a month ago.
Objection.
Yes.
Mr. Scheibmeier, the amendment to the school district project is not relevant to the access issue that we're here to be talking about today.
So let me just stop and do two things. My advice to you, Ms. Brown, perhaps understandably, wasn't fully understood, because what you have done is provide me with a closing argument. These are arguments, not testimony. That's not terribly meaningful other than it's sort of cut to the chase. It's telling me that you're not wanting to present new evidence, but you're simply wanting to argue that what's been done hasn't been satisfactory. And that's a legal argument, not testimony. It's what I had intended that you would provide once we got to final argument of all the parties. You sort of jumped the gun just a little bit on that. That's not the biggest thing in the world. It's just changed the order of things a little bit. And so I'm not interrupting you. You're well into it. Might as well be finished rather than stop and try to make that distinction. And once you're done, unless the parties have cross-examination, they may simply want to then make their final arguments. I'll ask the parties how they prefer. That really didn't get to Ms. Soto's objection, which is a bit different, which is questioning your testimony / final argument about the major amendment. I am having trouble seeing its relevance. And so I'm not sure if you want to make a few brief comments, but I'm not going to let you get into a long discussion of it, again, because of where I've been positioned in this hearing. I am having trouble finding its relevance. And so as part of your argument, I'll let you have a little bit of leeway in that, but not a lot. And so I'm partially granting Ms. Soto's objection, and I'll let you make brief comment about it, but I'm not going to have this turn into a forum on that amendment.
I appreciate your comment. It gives thought to that. Okay, I will cut what I was going to give, even though it's very, very brief. I will try to cut to the quick, as you said,
Thank you.
And provide new evidence as testimony here. As you know, on August 7th of this year, the Issaquah School District gave notice of the application by the district for a major amendment to the previously approved site development master site plan permit. As part of the application, the district submitted an entirely new set of site plans illustrating revised plans. This is what is important. It is a new, entirely different set of plans. And if we take a moment to consider the city of Issaquah's list of requirements for such site plans, this being the major authority for such permits, according to the permit requirements, submitted drawings must show the following: depict and label the location of all easements, utilities, locate and label all existing adjacent right-of-way, private street, access easements, and so forth, and include King County recorded numbers with easements. Demonstrate and label all on-site rights-of-way, easements, and their purposes. Given the very recent date of the major amendment, if any current easements or other planned construction were in place for the proposed Verizon C project, including driveways, utility easements and lines, and access easement, they would show on the major amendment site plans. But in fact, what does show up on the topographic survey sheet, C04 LU, are the utility and access easements to the water tower, WCF. Nothing about the new location. No introduction of a license agreement. In fact, if you look at sheet CO4 LU, the current proposed Verizon site itself is not even in the plan. In his decision, the hearing examiner stated they had supplied site plans showing the 1997 easement itself. However, the water tower and the lease area are nearby to one another, but they are separate locations and require access. The hearing examiner deemed these easements ineffective for the appealed site development permit. My final statement, but even if such new easements were shown, until the major amendment is considered by the Development Commission and until they reach a decision and a permit is issued, including any amended changes to the site plan, the Verizon C project cannot be considered. In fact, even the location of any new WC facility, which could potentially include, who knows, even retention of the water tower facility in its current place, is now subject to the final site plans of the major amendment, approval by the Development Commission, and issuance of the permit. In conclusion, in light of the current status of the master site plan and the absence of an easement, the hearing examiner has no choice, to my mind, and I appreciate your experience in this, other than to order for the current remand on ASDP 22-007 to remain in place. Thank you.
Thank you, Ms. Brown. Ms. Soto, Mr. Bush, as Ms. Brown's testimony has largely been in the form of concluding argument, but perhaps with some degree of testimony. Would you wish to cross-examine, or would you prefer to move to your concluding remarks?
I have no cross-examination for this witness.
And Mr. Bush?
I have no cross-examination for Ms. Brown.
Okay. Well, let's regard Ms. Brown's testimony as argument. And in light of that, that becomes her opening, her beginning, closing remarks. That's not oxymoronic. And we'll allow then both the applicant and the city to provide theirs, and we'll allow Ms. Brown a concluding statement. So with that approach, Mr. Bush, your final comments.
Yeah, thank you. I would like to address your question about the terms of the access rights. And what we're really doing is, like you mentioned, variance condition number one, making sure there's access to the site. The variance condition doesn't, the question you're raising through your questions of Ms. Taylor, I see this as more of a legal analysis of a contract rather than a fact statement from a witness. The question you're raising is when there's an access document, whether you call it a license or an easement, it's access rights, like you said. If there's a temporary interruption, does that automatically terminate the license itself? And it doesn't. It's very common for any access agreement to be effective, but have guidelines, terms and conditions, rules and regulations for when you can get in and when you can't get in. For example, if there's an emergency at the school, whatever type of emergency, fire, medical, and there's a lockdown, we can't get in, of course, we're not going to have access, but that doesn't terminate the license agreement. That doesn't terminate the right to access the property. The right is still there. It's just enforceable, continue to be enforced at a different time, but under reasonable terms and conditions. So you're asking an appropriate question about what about that right for the school district to say when they're bringing in the bulldozers and clearing out trees, you can't come in with your handbag. That doesn't terminate the license. The right to access is still there, like it says at the end of that first sentence, as long as the access rights are still provided. So you're raising a question about that gap between, well, the school district can say, no, you have to have something in writing. But though, if we ever get, in the unlikely event we ever get to that situation, that doesn't terminate the access rights. And when we go back to variance condition number one, what it's looking for is the access rights, not uninterrupted access rights, not access rights without any terms and conditions restricting access to the property. It's just having the underlying fundamental right to access the property. And that's what we have. So we think it's clear that the revision for the finalization of the long-term agreement that includes the access rights with reasonable terms and conditions that can't be terminated. Ms. Brown was arguing that they can terminate it. No, they can't. They can't. It's expressed in paragraph, help me, 6. That it is in effect must be provided throughout the term of the agreement, subject to reasonable limitations. I'm glad to answer any questions you may have, but I don't have any further comments. Thank you.
Thank you, Mr. Bush. I would follow up on the question I posed to Ms. Taylor. And so we have a situation in which, for some reason, the school construction poses a blockage to the acknowledged pre-construction route. And as a result, that access can't be granted. Part of the agreement says that in such instance, the city or the school district will seek good faith alternatives, but does not necessarily assure them. While earlier in the paragraph, as noted by Ms. Taylor, there is this overarching obligation to provide constant access. As perhaps as the drafter of this, or at least the negotiator for the applicant, and the one who would interpret it from the applicant's perspective if an issue arose, how are you interpreting those various provisions?
Sure. Unfortunately, I wasn't the negotiator, but set that aside. There's a gap between thou shalt do it, but then you have to have a document documenting it. And unfortunately, that's where a good lawsuit comes up as a practical, because you have to give it to me. You're not being reasonable. All contracts like this in Washington State are presumed they must be interpreted and enforced in a reasonable manner. The license agreement is treated like a contract. Reasonable terms and conditions are assumed. And if the school district is reasonably saying, look, we have people cutting down trees, you can't walk in or drive in, that's reasonable. But if they're saying, no, you can't stop by for 18 months because we're going to prune things, well, that's not reasonable. So that's where the rubber will meet the road. Okay. Again, I go back to, it's not going to, these access issues get worked out all the time. It doesn't terminate the underlying access right. It just, you accommodate it through reasonable solution. So I think the answer to the question is inherent in this license agreement is an obligation to perform reasonably under Washington State court decisions. And if there's a dead end, then it would be litigation to enforce the reasonable requirement. But by then the access result would have been resolved and it wouldn't be an issue.
Okay. Thank you, Mr. Bush. Ms. Soto, your concluding remarks?
Yes. So here what we had is the hearing examiner who in the underlying height variance application had included this condition that says prior to issuance of ASDP 22-00007, the applicant provides their access easement to use Providence Loop as access to the lease area or revise access location to a different location. It does not say that they had to provide that access in any particular format. Next, we had the appeal in the instant matter where the hearing examiner's decision specifically says that on remand, the department may modify ASDP 22-00007 if and only if the applicant submits revised site plans depicting lawful access to the lease area for the lifetime of the cell tower as required by, paraphrasing that variance. In no place in the hearing examiner's order does it say what format that access has to take, whether it needs to be an easement or if it could be a license or some other mechanism to provide those access rights. What we have here is really a distinction without a difference. It doesn't matter if it's an easement or a license, so long as the access has been granted. And that's what the city reviewed that was submitted to the city by the applicant, where it was the license agreement that did grant that access. That license agreement is binding on the parties. The city has no reason to believe that it is not binding or that it would be taken away. I recognize that while the agreement does have language about the term, and it does say unless earlier terminated, if that were the case, then as we've heard today with the testimony from the applicant, then the cell tower would need to be removed and there would be no reason for providing access at that time. So again, the city reviewed the materials that were provided by the applicant that satisfied the hearing examiner's condition in not only the variance, but also the hearing examiner's decision that resulted in this remand hearing, and appropriately granted the reissuance of the notice of decision for ASDP 22-00007.
Thank you. And Ms. Brown, any concluding remarks? Again, I'm taking into consideration the ones you've already made, but if you wish to respond further to Mr. Bush's or Ms. Soto's, you're free to do so.
No, I think
Okay, thank you.
my concluding remarks.
Thank you. I'm denying the appeal. I've given this a great deal of thought. This is most unusual in how it comes to me, in that it's the product of 4 prior hearings, which have framed, 2 prior hearings before the hearing examiner, 2 hearings before the board, that have framed the requirements for this facility. And it comes to me with that framework in mind. So I'm not to reconsider the decision. I'm not to change the viewpoint of the prior order. I am limited in my analysis to determining whether the one condition that Mr. Seidel's imposed has or has not been satisfied, with the board having concluded, or the city having concluded in a recent order or recent hearing that it has been satisfied. I affirm that decision by the board. There is an unfortunate poor use of words by Mr. Seidel's in at least one of his decisions, where he used terminology inartfully. And that was when he used the term easement agreement. That's not what he meant. It's clear that's not what he meant from the language. What he meant was an access agreement. The term easement is a term of art that people carelessly use in a broader sense. But reading his documents in their entirety, it's extremely obvious that he did not mean that in a hyper-technical sense, but meant it in a broader sense of providing an agreement that provides access. Access can be provided through a series of different documents. And in my background, in addition to a hearing examiner, I am a property law attorney. I deal with property law issues as well as land use issues all the time. Access can be provided equally by an easement document or a license document. They do absolutely the same thing. The only difference, well, there might be a few, but the most important difference is that an easement, what's called runs with the land, while as a license does not. That is that it's binding on successor owners. But in this case, successive ownership means absolutely nothing in this instance. It's not a distinction that has any value or adds anything to this process. And so the distinction between a license and an easement in this context is meaningless. What Mr. Seidel's meant, and again, as Ms. Soto has noted, his final order does not require an easement. But what he simply required was access. My concern about this matter has been far different. It is this access assured? Let's back up a little bit. The city's regulations do not require access for wireless facilities. So it's not an underlying requirement. And again, I'll take note that in the typical instance, once there's been construction, the need for access is to be, as a matter practicality very limited. There just isn't much reason. I simply note that it's not important one way or another in my decision, but simply note, as Mr. Bush was seeking to elicit, that once it's been established, its importance pales or diminishes greatly. I understand that. Nonetheless, Mr. Seidels imposed the requirement that it be demonstrated to be continuous. I find that the license agreement provides continuous assurance. Where I was getting and remain a bit hung up is that there is this language in the final license agreement that it's not as clear as one would prefer with respect to potential temporary blockages of the easement or temporary blockage of the access. But nonetheless, I don't find that to be problematic. As both he and his witness, Ms. Taylor, explained, there is overarching language in that agreement that assures continuous access to the site. That is what Mr. Seidels insisted upon. That is what this agreement provides. And that was the only thing that was left to decide following the earlier hearings. The city, upon review, concluded that that was met. I concur with the city's decision. I do not find any relevance to the major amendment to the site plans. By analogy, if Mr. Seidels had not had this one issue left for remand and had simply approved the permit then, the subsequent major amendment to the school district would have no bearing on his order, would not change things in any way, as long as, again, the agreement for access was assured. So the fact that it has been remanded for that single point doesn't open the door to all that, and that is an unrelated issue. Some of those points that Ms. Brown has brought may be points to bring up in the major amendment review. I'll leave that to the parties. But as to this review, they are not relevant. They are two ships going in different directions, not related to each other. And again, I've been repetitive in this. I apologize for the degree of repetition, but I come to this hearing with a set of blinders on that are extremely narrow in their scope. I am not being asked to reconsider anything about the prior order or its relationship to the school and school district other than access through the school district property. The applicant has provided to the city's satisfaction of constant access. I concur with that. Beyond that, I am not empowered to make any other decisions about the relationship between the two. So, which is difficult because it makes it appear that I'm unduly single-minded, but that's because I am legally required to be so. And hence why I find information regarding the major amendment to not be relevant to the limited authority I have in this hearing. So again, I'll reduce this to findings, conclusions, and a decision. I will do so in a timely manner. That decision is with any appeal subject to appeal through the Land Use Petition Act LUPA process. But again, I will do that within the required time. Ms. Brown, you were about to raise a question. What is your question?
Yes, could I make a concluding? I understand I can make a concluding statement.
No, you can't. No, that was what you were allowed to do earlier, and there aren't 3 opportunities for that. You were allowed to conclude in your testimony. You were allowed to conclude following Ms. Soto and Mr. Bush's arguments, and you declined to do so. You don't get to make an argument after I've rendered my decision. There is no authority for that nonsense. I'm sorry?
I apologize. Conclusion to my testimony. I understand they both afterwards, I spoke, then they got conclusion.
No.
I haven't
No, let's try that again. You
Okay.
testified, you testified,
What is called a temporary possible blockage.
wait a minute, no, I'm not, okay, thank you. You testified, neither one cross-examined, so there wasn't a right to testify further. What you did instead was make argument, which then prompted their final arguments, and you were allowed to make a final argument after they did. You were given the final chance to argue, and you declined. So that then rendered my decision. I've made my decision. There isn't the opportunity for further testimony after that. So we are concluded with all presentations, and I have rendered my decision. You can, Ms. Brown, you may shake your head if you disagree, that's fine, but you were given that full opportunity.
They give their conclusions.
What's that?
I have not given the conclusion yet after theirs.
I asked you if you wanted to, and you said you did not wish to. And that's when I rendered my decision.
Okay, but I feel I've been treated unjustly.
Well, that's unfortunate you feel that way, but it is not the reality. You were expressly given the opportunity to make final argument after both of those counsel did so, and your comment was that you did not wish to make any additional argument. Now, if you may have interpreted that in some different way, it's unfortunate if you did so, but that was your opportunity to express any additional comments you wanted, and you expressly declined. So I'm not reopening because I have made my decision. To reopen would be to invite challenge to my decision. That's not how that works. And so again, the procedures were followed, the opportunity was made, and I, after all of that, rendered my decision. So we are concluded with presentations.
One last thing, just you asked me if I wanted to cross-examine the vote. That was my understanding. My understanding was that we were all going to give a conclusion after that.
Ms. Brown, I'm going to stop you. All right. I really don't know where some of those beliefs come from because they aren't accurate. There isn't such an opportunity. The opportunity comes with the presentation by the witness. That's as long-standing a policy as it exists in law. That's nothing new or different or unique, and there is no such later opportunity to represent. You could have called them as witnesses if you had sought to, but I asked you if you had any other witnesses, and you said you did not. You were in fact allowed to cross-examine each one of them at the time. You don't get two chances to cross-examine, you get one. So with all due respect, the things that you may have hoped to do are simply inconsistent with the process that was followed, and the process that was followed was thorough and complete and fair. And so nothing about it was picking on you.
I was not given the opportunity for a closing remarks, and I'll leave it to you.
Okay, so noted. And my comment to that has already been made. So with that, we are in conclusion with our presentation. I've made my oral decision. I'll reduce that oral decision to the required written format as quickly as I can and have that back to the city. And with that, we are adjourned. Thank you.
Thank you.